Court is now in session this October 8, 2025. The time is now 10:20 a.m. Matter on the court's docket scheduled for 9:30 is Rocket Mortgage LLC, formerly known as Quicken Loans LLC versus Amanda Stevie, file 47-2025 CV 318. This is an order to show cause concerning attorney Tyler Wyrick and Halliday Watkins and Mann PC. Is Mr. Wyrick present?
I am, Your Honor.
Please come forward and have a seat. The court notes that attorney Nesbitt?
Correct, Your Honor, Nesbitt.
Mr. Nesbitt is present. On behalf of Halliday, Watkins, and Mann, court notes that the original respondents in this matter do not appear. Ramon Stevie and Amanda Stevie and any person in possession. Those three entities do not appear. This is both a contempt order to show cause and an order to show cause issued under Rule 11 of the North Dakota Rules of Civil Procedure. The underlying matter is an unlawful detainer forcible eviction action initiated by attorney Wyrick, counsel of record for the plaintiff, Rocket Mortgage LLC, formerly known as Quicken Loans LLC, against those defendants previously mentioned in Stutzman County. Attorney Wyrick noticed a hearing on the matter for July 2, 2025 at 10:30 a.m. or as soon as the matter may be heard. The court allowed attorney Wyrick to appear by reliable electronic means. The hearing was called on July 2, 2025 at 11:13 a.m. There were some technical difficulties in a hearing before that hearing, which caused a delay. The court notes that there was a delay in calling this hearing as well in light of previously scheduled matters that ran longer than expected. At that July 2, 2025 hearing in the underlying matter, the court again called it to the bar at 11:13 a.m. Central Time. At that time, neither the plaintiff nor the defendants appeared in person or by reliable electronic means. And the court dismissed the matter on the record without prejudice. Later, at approximately 12:08 p.m. Central Time, attorney Wyrick contacted the court's recorder and judicial secretary, Lori Strom, claimed that he was not present because he miscalendared the date and time of the hearing using mountain time rather than Central Time. Attorney Wyrick requested to reschedule the hearing. The court's direction, recorder Strom informed attorney Wyrick that because both parties failed to appear, the court assumed the matters had been resolved and dismissed the action without prejudice. And again, at the court's direction, Ms. Strom responded that attorney Wyrick would need to refile the action to reschedule it. On or about July 2, 2025 at 1:51 p.m. Central, attorney Wyrick responded, "Thanks for the follow-up. I suspected that would be the outcome of the hearing, unfortunately. The matter was closed in the Odyssey case management system." Approximately 2 months later, on September 8, 2025, the court received proposed findings of fact, conclusions of law, and order for judgment, and a proposed judgment. That's record index 16 and 17. No service document was filed in conjunction with the proposed documents, indicating who in particular filed the documents, nor indicating that the proposed documents were served by or as required under North Dakota law on the defendants. However, the text associated with those filings described the documents as, quote, filed by Tyler Wyrick. The proposed findings in judgment were not for that of dismissal for failure to appear, but rather described a hearing which did not happen, an appearance by attorney Wyrick who did not appear, and proposed findings of fact and conclusions of law consistent with the relief the plaintiff originally sought. which was inconsistent with what the court actually did at the hearing. Again, those documents were filed approximately 2 months after Attorney Weirick had actual knowledge the court had dismissed the matter. Attorney Weirick is employed by or associated with the law firm of Halliday, Watkins and Mann, a foreign professional corporation registered in North Dakota with office listed in North Dakota. The court, on its own accord, under North Dakota Century Code section 2710.01.1C and 2710.07, found that there was a prima facie case concerning contempt and issued an order to show cause. The court made similar findings that under North Dakota Rule of Civil Procedure, Rule 11B, that by filing and submitting the proper documents, that the attorney certifies that the pleading, written motion, or the paper is not being presented for an improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation, or the factual contentions the factual contentions have evidentiary support or likely to have evidentiary support after reasonable opportunity and further investigation or discovery under Rule 11C. And again, under Century Code section 2710.07, the court issued the order to show cause that we are here to address right now, naming Attorney Tyler Weirick and the law firm, which is allowable under Rule 11C, to show cause why they should not be held in contempt and or the court should not impose Rule 11 sanctions for filing essentially a frivolous document. Since that time, Attorney Weirick filed a motion to withdraw the filings. That motion, after complying with Rule 3.2, just became ripe a week ago or less than a week ago. The court has not taken any action on that motion. The motion wasn't accompanied by a proposed order. Thereafter, Attorney Weirick and Halliday both filed responses to the court's order to show cause. And so just to be clear, the order to show cause issued by the court is in the record as Record Index 18. The motion to withdraw docket number 1617 in the record as Record Index 25. Mr. Weirick's response to the order to show cause is in the record as Record Index 36. Mr. Nesbitt's response on behalf of Halliday, Watkins and Mann is in the record as Record Index 40. As with any order to show cause where the court is considering contempt, the primary purpose of remedial contempt is to impose a sanction conditioned upon performance or non-performance of an act required by court order or to induce compliance with a court's order. Primary purpose of punitive contempt is to unconditionally punish contemptuous offenders and vindicate the court's authority. As relevant here, contempt is defined by statute to include intentional disobedience, resistance, or obstruction of the court's authority, process, or order. In considering contempt sanctions, the court must first determine whether the contempt it is considering as remedial or punitive, and then apply the applicable procedural elements, procedural process for doing that. Here, to the extent the court is considering a contempt sanction, any contempt sanction would be remedial. That is the process the court is using. Remedial sanctions that are available to the court under North Dakota Century Code Section 2710.1.4 include compensatory reimbursement of money, including cost expenses for attorney's fees, to a party other than the court directly related to loss or injury suffered by contempt. Jail for as long as the contempt continues or up to 6 months, whichever is less. A $2,000 forfeiture per day until the contempt ends. An order designed to ensure compliance with the previous court's order, or any other sanction if the court finds that the previous sanctions would be ineffectual to stop continuing contempt. Under Bloomdahl versus Bloomdahl, 2011 ND 78, for the court can consider imposing contempt, there needs to be a valid and enforceable order or judgment. All parties where contempt is considered have the following rights. They have the right to be personally present in court, the right to reasonable written notice of any allegations in an order to show cause or warrant of attachment, the right to bail if a warrant of attachment is issued or if jail is contemplated, the right to attorney representation and consultation. That right is the right to retain a privately retained attorney or proceed pro se if jail is not considered. If jail is a potential sanction and the court indicates that it's likely to impose jail as a potential consequence, alleged contemnor also has the right to a public defender if they financially qualify for one, the right to reasonable delays to prepare for the hearing, the right to an evidentiary hearing and an opportunity to be heard, standard of proof and burden of persuasion, generally require clear and convincing evidence for remedial sanctions. The conduct that is contemptuous must be willful, intentional, inexcusable, or unjustifiable. The defendant or the respondent bears the burden to establish any defenses such as justification or impossibility. The rules of evidence apply to contempt proceedings except summary contempt occurring in the court's presence. The right to confront and cross-examine witnesses against the contemnor. The right to testify or to remain silent, to present evidence and call witnesses and use the court's subpoena powers. Mr. Weirk, do you understand your rights?
I do, Your Honor.
Mr. Nesbitt, on behalf of Halliday, do you understand your rights?
I do, Your Honor.
All right. And so the court outlined its concerns with the filings in its order to show cause. I'll let Mr. Weirk go first. So, sir, go ahead.
Thank you, Your Honor. I appreciate the opportunity to address the court and to be here. I want to begin by acknowledging, Your Honor, that this is certainly something to be concerned with. Quite candidly, when I received the order to show cause, I was kind of gobsmacked by it. This is not, I've never been in one of these hearings before in my 20 years of practice. I was stunned and shocked and upset and everything the above, but I also understand. I mean, on the court's record are these two documents in a case that had been previously dismissed, and I think that is a concern. That said, I take full responsibility for it. I mean, it was my duty, my staff. It was, I'm the one that did it, and it's my responsibility. And for that, I sincerely apologize to the court. That certainly wasn't my intent. My intent was completely different. My intent was not to file the documents. Indeed, as I mentioned in my briefing, my intent was to actually cancel the filings. Let me just kind of give a background on how our systems work, and so the court understands what exactly happened here. So we have a computer system that kind of tracks our cases, all right? And that computer system takes tasks and takes like an overall task and breaks them into subtasks. So, for example, preparing an eviction case, we would prepare a brief that would be forwarded to me. I would review the brief, make all the changes I want to make, I would add in all the language I need to add in. Once that's done, I would review it, and then I would send it to our filing group to have it filed once I approved it. So the last approval was on me. That system is the same system that we use for when we're preparing orders and things like that. So with regard to what happened in this particular instance, so we prepared the summons and complaint. And generally we prepared everything at the same time. They kind of go into two different directions. So the summons and complaint come to me, I review, get them filed. The orders go separately and don't show up on my queue until the day of the hearing. And so when the hearing didn't occur, what I should have done is gone in and completely just canceled them out. But because of the nature of the hearing, Your Honor, because it was a dismissal, and I knew that I had to refile or file a new case since it was dismissed, I left those documents in my queue as a reminder, which I shouldn't have done. I should have set a calendar reminder. That would have made more sense. I set those as a reminder, though, because I didn't want to have to go through the process of filing a new complaint and going through all the machinations of setting a hearing and having a hearing if the property was vacant, because it had some information that the property might have been vacant. And so what I did is I asked for an occupancy check. I requested that my client send somebody out there. While that occupancy check was in place, I left the item open as it related to these orders, this order, and kind of used that as a reminder to check on things. So we got the occupancy check back. I believe, I don't recall the exact date. I think it was about a week before I went into the system and went to cancel these out. My occupancy check came back that it was vacant, so the follow-up hearing wasn't needed. And so I went into the system to cancel out the proposed order, proposed findings of fact, and the proposed judgment. My options there were to cancel it or to, which was kind of a separate thing, but my options were to cancel it or to approve it. And I inadvertently approved it, which, since I am the final gatekeeper, that sent it to my filing team to file it. And so they filed it. Again, it's no one's fault but mine. There was, my intent was not at all to file those documents. In fact, it was the exact opposite. My intent was to cancel those out so, the case would have been done because I would have no longer needed the eviction action to continue. So that's kind of the backstory, Your Honor, on how this filing happened. Now, that doesn't take away from the fact that I filed documents into a closed case. And that's where we have to look at, the court's order to show cause. I mean, the court has, indicated that it is seeking this order to show causes for Rule 11 sanctions and for contempt. Those are both very serious, and I take them very seriously. So the question becomes whether or not I and my firm should be sanctioned. Actually, before I get into that, let me back up just 1 second here. So when I received the court's order to show cause, I got it sometime in the afternoon of the 11th. I immediately forwarded it along to the power to be at my firm. And then I immediately looked into how in the world this happened because I was kind of shocked by it. It was actually not just kind of, I was very shocked by it. And so I spent it well into the evening trying to figure out how this happened, put together the motion to withdraw and the declaration, the brief, and file those the next day. In the meantime, the firm also investigated what happened, and Zach or Mr. Nesbitt can give you a little more on that. But as a result of that, the firm changed how we do things. Those documents are not prepared simultaneously anymore, or even at the day of trial. The attorney actually now has to go in and specifically authorize the findings of fact, conclusions of law, and judgment to be prepared. So on the day of a hearing, a note pops up, and we have to go in there and say, what was the outcome of the hearing? Do these documents need to be prepared? So that has addressed that particular issue. As for myself, obviously I'm keenly aware now, and I don't leave things open as reminders like that. I've switched over completely to a different note keeping or a to-do list keeping system. So I don't have a situation where where I can accidentally approve a document that should never, or approve documents that should never have been approved. Let me swing back to the issues here before the court in the order to show cause. The documents that were filed, Your Honor, were prepared in good faith with the belief that there was going to be a hearing. But the fact of the matter is, because the hearing didn't happen at the time they were filed, they were incorrect. I mean, I obviously did not appear. And the court obviously didn't hear a hearing. And
Well,
what's
the hearing happened. You just weren't
sorry.
there.
Yeah, that's correct. The hearing happened, but I wasn't in. That's correct. And on that note, Your Honor, let me actually talk. Sorry, I meant to cover that as well. And so what I've done on hearings now as well is, because I live in St. George, Utah. I live in the Mountain Time Zone. I practice from St. George. So everything's an hour behind, which can create scheduling conflicts, which is exactly what happened here. So what I do now is everything I do on my calendar, I schedule in Central Time. And so and not only do I schedule it so it shows up on Central Time, I go in every Monday morning, I have a reminder, and I go in and I check my dockets for the next week, and usually 2 weeks, to see and to compare notes to make sure that my times are correct, to make sure that I don't do that again. Because yeah, that's, we do have a couple of issues we're dealing with here because of the failure to appear as well. And I can tell you, I don't make a habit of that. That's, again, I've had a long career, and I am terrified. I was terrified when that happened too. When the failure to appear happened and we realized what was going on, I was on the Zoom call and nobody was showing up, and I was just trying to get a hold of people saying, hey, where is everybody? What happened? And so it took me a while before I got an email to the right place to find out that indeed I was an hour late to the hearing. So, but let me step into the Rule 11 and into the contempt issues. Under Rule 11, it's an objectively reasonable standard, whether or not the filing was made for an improper purpose, like to harass, delay, or needlessly increase the litigation costs. Your Honor, there was no intent at that time. My intent was to do the complete opposite. My intent was to cancel the documents, not file the documents.
So I'm going to stop you right there.
Okay.
Mr. Werrick, how do I know what your intent is? So when those documents, when they were received, how do I know that you didn't intend to file them with the hopes that 2 months later, if it were me, that I would have forgotten about what happened 2 months ago? Or if it were a different judge, because when we're talking about eviction actions, they're not assigned to a particular judge. I'm one of 7 judges in this district. And so we rotate through the chair that I'm sitting in right now. And when an eviction action comes through, whoever happens to be on the master calendar docket that day is the judge that deals with it.
Fair.
So when I received first of all, the day of the hearing, that was me just randomly being assigned to the master calendar that day. So when I made my ruling, that was random. It could have been the judge sitting in the back of the courtroom. It could have been one of the other 6 other judges in my district.
Sure.
When filings come in, those filings also go to the master calendar judge sitting on the bench that day. I happened to be, again, when I received those filings, I just happened to be sitting in this chair. It could have been one of the other six. And because you're an attorney, we rely on attorneys to tell us the truth about what happened at a hearing. Another judge most likely would have signed those filings, not knowing what happened. It just happened to be the luck of the draw that I happened to be sitting on the bench that day. That's what poses such a huge concern for me, because we don't have, unless the case is assigned to us, unless it's assigned to me, I don't track what happens in Judge Naram's cases or Judge Schachman's cases or one of the other judges. So if another judge would have reviewed that, it is highly likely they would have signed off on it without knowing what happened. They would have trusted the attorney under Rule 3.3's candor requirement
Sure.
to sign it. And that document would have been effective. It would have impacted rights. It would have been effective and enforceable up until the point that one of the Stevies or some other party found it, appealed it, or the district court vacated it. And it affects credit, it affects housing programs, it affects their ability to get a different kind of mortgage. It has all sorts of implications. And that order would have been effective until it was appealed or vacated. So that's why it's such a big deal for me. I just happened to be the judge that remembered it. And another judge likely would have signed off on it. So with respect to that, circling back to the rule, how do I know what your intent is? And do I have to take your word on it, saying it was an accident? What's the intentional conduct? Is the intentional conduct hitting submit file, or is the intentional conduct to mislead the court? So when we talk about scienter or mens rea associated with either contempt or with Rule 11, what's the conduct that is potentially contemptuous or a violation of Rule 11? It's the act of filing, right? And your filing team filed it intentionally on your direction for whatever reason, right?
They did file it indeed.
So I just wanted to get that straight. The question is, if we're talking about your intent, you have asserted, and I don't have reason, there's nothing in the record that says otherwise, why I should disbelieve you. But that being said, I have children, and when one of them punches the other, and I said, why'd you do that? And he says it's on accident, do I believe him? Probably not, right? So do I have to just take you at your word that this was an accident? And does that matter because the intentional conduct was pressing file? And frankly, after having done this as a litigator, I know how it works when you file something in our Odyssey system. You enter it in, you have to put a descriptor of what document you're filing, you have to add it, and then when you say, I accept this, it sends a review saying, finally review before you submit, and then you have to click submit. So there are several steps there that require affirmative action. And isn't that the intentional act that I should be worried about?
Your Honor, yes and no. Yes, it is an intentional act, but I think that there are circumstances here that we also have to consider. I mean, the case was indeed closed at the time that the filing took place.
Which should have raised extra red flags, right?
And certainly we can go back and talk about that with my staff. You're right. But there was no certificate of service, as the court mentioned a minute ago as well. I mean, The other parts of it, which I'd mentioned, is, it clearly had some mistakes in it that I don't, I usually fix before I send out and all of that. But I think that while I understand where the court is coming from and I understand the gravity of it, I think that in consideration that it was filed in a closed case, there wasn't a certificate of service, raises some questions as to whether or not there was the intent to file it. And so, I think that those things have to be taken into account as well.
Okay, continue.
So when the filings occurred, like I'd mentioned, the case had been dismissed by the court. There was no opposing party in the matter. They hadn't appeared. There was nothing from a standpoint for me to be gained or my clients to be gained by filing the document.
What happens if I disagree with you there? So isn't there something to be gained by not having to go back to Rocket Mortgage and say, I didn't show up and that's why the judge dismissed this case? Isn't there something to be gained by not having to explain to a senior partner or a malpractice provider, this is what happened and the case got dismissed? Isn't there something to be gained monetarily? Because a client probably isn't going to pay you if the case was dismissed because of an error made by counsel. Aren't those things that could be gained by filing a document in the hopes that a judge would sign off on them?
From a theoretical perspective, yeah, I think that the court is correct there, but that's not how I operate. That's not how this operated. As soon as we found out, as soon as I missed the hearing or the hearing, we let the client know, and that's why we did the check. Another reason why we did the occupancy check.
But I didn't know that. So when I issued the order to show cause, none of that information was before me. So that's an important issue.
And I understand that, Your Honor.
All right. Any other argument?
Well, Your Honor, other than going back to this concern about there's improper motive or objectively unreasonable conduct. I understand where the court's coming from on that, and to an extent, I think I have to rely on the court and say, it was an error, and we corrected it as soon as we found out. And swinging back to what happens if a judgment would have been entered, it would have been immediately set aside. I would have gone in there and we would have set it aside. Because that's, we monitor those things very closely on the judgment side. And so, Your Honor, the willful conduct is not there in the sense that there was no intentional filing with the court. There was no intent of nefarious conduct or things like that. And I appreciate that the court's position and bringing this to our attention. The error, Your Honor, was inadvertent, and I know it's on the court to decide how to deal with that. And again, the best I can do is apologize and let the court know that we've reworked our systems and fixed this error that resulted in this being filed. I'm not sure I have anything further this time. Do you have additional questions?
I do not. Mr. Nesbitt, do you have questions?
Not questions, Your Honor. Just I'd like to point, that the firm also, once this was discovered, did its own review and found that, that the facts as Mr. Warg has laid out, it appears to be what happened is that, the hearing was missed, that he didn't appear, and that then he held this matter open because we were confirming that it needed to be refiled, because it appeared that the property may be vacant. And then it looks like when he went to close the steps or cancel, certainly told the filing team to file it. However, it did happen. And so the firm's position is that was unacceptable. We've had conversations with Mr. Warwick about that, but we've taken remedial steps to prevent this from happening again in our system. First, as Mr. Warwick mentioned, we've added a step now where those documents are not prepared till in fact necessary. So for the attorney to edit, after the hearing, the hearing has to actually occur first. So we've changed that process. Additionally, we've retrained staff. One of the things that we do is when the attorneys get the documents, they're in Word format. And when the attorney is done with them, the attorney is supposed to change them into a PDF format so they can't be changed. I've talked to the filing team. It appears some of them, in an intent to be helpful, we're actually sometimes PDFing things. Just the instruction is that they're to return.
Mr. Nesbitt, you're
So
cutting out, so I'm hearing about every third word you're saying.
Apologize, Your Honor. Apparently my internet connection. I'll speak up. Sometimes that helps. But so that will no longer happen. That Word versions that are sent to the filing team will be returned to the attorney to in fact verify that they are to be filed. So that would have stopped this issue in its tracks there. And finally, we've trained both the eviction team when they're scheduling things to make sure that they're scheduled on the attorney's calendar, and also retrained attorneys to confirm, as Mr. Warwick said, that their calendars are correct. That was an expectation before, and we've reemphasized that. So the firm has taken steps to make sure this doesn't happen again. This embarrassing moment never happens again, and that we've also talked to Mr. Warwick about this to make sure this doesn't happen again, Your Honor.
Anything else, Mr. Nesbitt?
No, Your Honor.
Just because we sort of blended the receipt of evidence and argument, Mr. Warwick, I'm going to have you stand and raise your right hand. Sir, the testimony you're about to give, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Indeed, yes, I do.
You can lower your hand and have a seat. Mr. Warwick, you did file a declaration in this case concerning your motion to withdraw index 16 and 17 in the record as record index 28.
That is correct, Your Honor.
And in that declaration, you made certain assertions under penalty of perjury concerning the factual process of what happened in this case. Is that right?
That is correct, Your Honor.
Do you adopt and incorporate as your testimony today the declaration you filed in support of that motion?
Yes, I do, Your Honor.
Do you have any changes or additions or any additional testimony you want to present concerning that declaration?
No, Your Honor.
Anything else that you want to put on the record as part of the evidentiary record, sir?
No, Your Honor.
All right. Mr. Nesbitt, do you have any questions of Mr. Warwick under oath?
No, Your Honor.
All right. So that was the questions that I had. Thank you, Mr. Warwick. I just wanted to make sure that it was clear that I was receiving that declaration as evidence.
Thank you.
All right. Mr. Warwick, your position is you're still asking the court to withdraw those motions?
That is
Or
correct.
Withdraw those filings?
Yes, Your Honor.
All right. Any other argument on either the motion to withdraw or the order to show cause?